when we talk about justice and protection, especially in really sensitive areas like domestic violence, the law needs to be, well, more than just words on a page. It needs to be clear, comprehensive, and adaptable, A living thing capable of actually safeguarding human dignity and safety.
Exactly, a practical tool.
And that's exactly what we seem to see with South Africa's Domestic Violence Act 116 of 1998.
It certainly aims for that.
So our mission today is to take a deep dive into this really vital piece of legislation. We want to make it accessible for you, whether you're just a curious citizen or maybe a law student looking for a deeper understanding.
Right. Break it down.
We'll explore its core purpose, its key provisions, how it actually functions within the legal system, its practical implications, and its real-world significance.
And the updates are important, too.
Yes, definitely. We'll highlight the crucial amendments, especially those from 2021 and 2023, because they show how this act has evolved, how it's trying to tackle modern challenges. Let's get started. To truly grasp the power of any law, I think we have to start with its why. What prompted this specific legislation? What foundational principles is it actually built on?
Well, what's really insightful here, I think, is how directly the Act confronts the issue. Its preamble is remarkably clear.
Okay.
It recognizes that domestic violence is a serious social evil. It acknowledges its, well, alarmingly high incidence within South African society.
It says that right up front.
Right up front. And importantly, it identifies victims as being among the most vulnerable members of society. This isn't just legal formality. It feels like a stark public admission of a really pervasive problem.
Wow.
The Act also emphasizes, that domestic violence takes on many forms, and it happens in a wide range of domestic relationships.
Not just marriage.
Not just marriage, exactly. And crucially, it highlights that the existing legal remedies that were available to victims had, frankly, proved ineffective. That really underscores the urgent need for something stronger, something new.
So this isn't merely about creating a new set of rules, then. It sounds like it's deeply rooted in upholding fundamental human rights. Is that fair to say?
Absolutely. If you connect this to the bigger picture, the Act specifically states it has regard to the Constitution of South Africa, particularly the right to equality and to freedom and security of the person.
Okay, so grounding it constitutionally.
Precisely. It firmly roots the legislation in the nation's core human rights framework. It also acknowledges South Africa's international commitments, things like the UN Conventions on the Elimination of All Forms of Discrimination Against Women and the Rights of the Child.
Right, CEDAW and the CRC.
Exactly. Commitments to end violence against women and children. So ultimately, the Act's stated purpose is very clear. Offer victims the maximum protection the law can provide and ensure state organs fully implement its provisions, basically declaring the state's commitment to eliminating domestic violence.
So what does this all mean for you, the listener? It means this act isn't just some dry legal document. It's really a powerful declaration of a nation's resolve to protect its most vulnerable people.
Rooted in rights.
Underpinned by core human rights and international obligations. It's almost like a statement about the kind of society South Africa is trying to be.
Yes, an aspirational statement backed by law.
Now, one of the most, I think, groundbreaking aspects of this act is how expansively it defines both domestic relationship and domestic violence. This seems to move far beyond sort of conventional ideas of abuse within a marriage. What's captured by this broad approach?
That's where the Act really shines in its realism, I'd say. Section 1's definition of a domestic relationship is incredibly comprehensive. It really tries to reflect the complex realities of abuse.
Okay, like what?
Well, it covers people who are or were married, obviously, including customary or religious marriages. It covers those who live or live together in a relationship that's like a marriage, whether same sex or opposite sex.
Right. Parents of a child, or anyone with parental responsibility for a child. Family members related by blood, affinity, or adoption. Standard stuff so far.
Okay.
But here's where it gets really expansive. It includes any engagement, dating, or customary relationship, even actual or perceived romantic, intimate, or sexual relationships of any duration.
Any duration, wow.
Yes. This means protection extends even to very new or, informal connections.
Well, it's huge.
And furthermore, it includes persons in a close relationship who share or shared the same residence. And close relationship itself is defined by factors like trust, dependence, intimacy.
So housemates could potentially be covered.
Potentially, yes, if that element of a close relationship involving trust and dependence is there. It aims to ensure almost no one in an intimate or close living arrangement is left unprotected.
That's a remarkable expansion. It really feels like it covers the full spectrum of relationships where abuse can, unfortunately, occur.
Now, let's talk about the definition of domestic violence itself. This goes far beyond just physical harm, doesn't it?
Absolutely.
Yeah.
The act recognizes the insidious, often invisible ways abuse manifests. Beyond the obvious physical and sexual abuse, it explicitly defines things like emotional, verbal, or psychological abuse.
Which can be so damaging.
Immensely. Things like insults, degradation, gaslighting, it's all potentially covered.
Yeah.
Then there's economic abuse.
How is that defined?
It could be anything from, say, depriving someone of financial resources they're entitled to, or unreasonably controlling their money or assets, exploiting their resources.
Okay.
It also lists intimidation, harassment, spiritual abuse, and damage to property. But what's particularly innovative are the updates from the 2021 Amendment Act. These additions tackle modern challenges head-on.
Right, the law catching up.
Exactly.
Yeah.
So now it explicitly includes sexual harassment, unwelcome sexual attention, behavior, including implied threats or rewards based on sexual cooperation. There's related person abuse. Basically, threats or violence against someone close to the complainant family, household member, someone in a close relationship where that action actually causes harm, even indirect harm, to the complainant.
Hurting someone to hurt someone else.
Precisely. It recognizes that tactic. Then there's elder abuse, specifically linking to the Older Persons Act, recognizing vulnerability within domestic relationships. Coercive behavior, forcing someone to do something they have a right not to do, or stopping them from doing something they have a right to do.
Like controlling their movements or choices.
Exactly. And that ties into controlling behavior, actions that make a complainant dependent or subservient. Things like isolating them from support networks, exploiting their resources, depriving them of independence, regulating their everyday behavior.
That sounds very encompassing.
It is. It also explicitly includes exposing a child to domestic violence, intentionally causing a child to see or hear domestic violence or experience its effects. This recognizes the profound trauma, even if the child isn't directly targeted.
That's so important.
And finally, unauthorized entry into the complainant's home, workplace, or place of study without consent.
Okay, quite a list. And what links all these different actions together?
The crucial link, the qualifier for all these forms of abuse, is where such conduct harms, or, and this is key, inspires the reasonable belief that harm may be caused to the complainant. It looks at both actual harm and the fear of harm. Perceived danger matters.
That comprehensive list truly shows a deep understanding, or at least an attempt to capture, the many insidious ways abuse can manifest, well beyond just physical violence. What stands out to you, the listener, from this remarkably broad and contemporary definition of domestic violence?
It's definitely something to reflect on.
Okay, so with such a broad understanding of what constitutes domestic violence and who is covered, how does someone actually seek protection under this act? What's the practical process for an individual to get help?
Right, the how-to. The process usually begins with applying for a protection order, which is detailed in Section 4. A key feature here is that it's typically an ex parte application initially.
Ex parte, meaning?
Meaning it can be made without the person accused of the violence, the respondent being present at first. This is absolutely crucial in urgent situations where someone needs immediate protection. You can't wait for the other side to be notified if you're in danger now.
Makes sense. And how do you apply?
An application can be submitted the traditional way to the clerk of the court. But importantly, it can now also be done electronically. That's a big step for accessibility, especially for someone who might find it difficult or dangerous to go to court physically.
Definitely lowers the barrier. And who can apply?
It's also very inclusive, the complainant themselves, obviously,
Yeah.
or someone on their behalf. The Act calls them a functionary, which could be a professional like a social worker, a healthcare provider, an educator acting in a supportive capacity, or really anyone with a material interest in the complainant's well-being.
So a friend or family member could potentially apply.
Yes, if they have that material interest. And importantly, even a child or someone on a child's behalf can apply for a protection order, potentially without parental consent if it's deemed in the child's best interest or the child can't consent themselves.
Okay, and what happens?
If the court looks at the initial application and finds sufficient evidence, what lawyers call prima facie evidence of domestic violence, and believes there's an immediate need for protection, it can issue an interim protection order quite quickly.
So fast relief.
Yes, it provides that quick, temporary relief. Then the respondent is served with the interim order and given a chance to come to court and present their side of the story before a final order is considered.
Okay, so due process is still followed. Now, this act has clearly been updated to reflect our modern world. And you mentioned the 2021 amendments. What's particularly innovative there? I heard they introduced some really game-changing measures.
Absolutely. These amendments show the act adapting. One of the most significant, I think, is the Domestic Violence Safety Monitoring Notice under Section 4A. This is potentially huge, especially for complainants who still share a residence with the respondent, which is a very common and dangerous situation.
How does that work?
Imagine you're afraid in your own home. The court can now actually order the local police station commander to direct a police member to contact the complainant at regular intervals, electronically, maybe SMS, WhatsApp, just to check on their well-being.
A regular check-in.
Yes, but it goes further. The police can also be ordered to visit the joint residence at regular intervals, to physically see and communicate in private with the complainant.
Wow, actual visits.
Yes. And here's the really critical part. If a police member arrives for a visit and is prevented from seeing the complainant, maybe the respondent blocks them, they can enter the joint residence, using reasonable force if necessary, specifically to communicate in private with the complainant.
That's a very strong power, a proactive safety net.
It really is. Then we have the provisions dealing with electronic communication service providers, or ECSPs, under Section 5B. This directly tackles cyber violence, which is, as we know, a huge and growing concern.
So online harassment, threats.
Exactly. Electronic communication, emails, social media messages, texts was used to commit an act of domestic violence. The court can direct the ECSP, like the cell phone company or internet provider, to furnish particulars. Things like the identity number associated with the communication, the name and address of the person assigned to it.
Helping to identify the abuser.
Yes. And the court can also order the ECSP to immediately remove or disable access to the offending electronic communication. Take down the post, block the account sending messages, etc.
That's powerful. Who pays for that, though? Does the complainant have to cover the costs from the provider?
That's a good question. The Act says the complainant is generally liable for the costs. However, the court can hold an inquiry into the complainant's financial means and, crucially, can order the state to pay those costs within available resources. So it tries to ensure access isn't solely dependent on finances.
That's an important safeguard. Anything else major from the updates?
Yes, one more key administrative improvement. The Integrated Electronic Repository for Domestic Violence Protection Orders in Section 6A. Basically, a national electronic database.
Why is that needed?
It's developed and maintained by the Director General of Justice, and it ensures all applications, orders, variations, warrants, related documents, everything is captured and accessible electronically across the country. This vastly improves coordination between courts, police enforcement, data collection, and tracking repeat offenders. It prevents things getting lost in paper files.
Right, making the whole system more joined up and efficient. These new provisions really show a strong legislative effort to adapt, to strengthen protection in, well, an evolving world, offering more tangible, real-time safety measures.
Definitely a move towards modernizing the approach.
Okay, so once a protection order is actually in place, what exactly can it do? What kind of powers does the court have to ensure someone's safety and well-being? Because this isn't just a piece of paper, right? It carries real legal weight.
Indeed it does. The court's powers, which are mainly outlined in Section 7, are quite extensive and designed to be practical. A protection order can impose various prohibitions on the respondent, things designed to create that buffer of safety.
Yeah, what?
Obvious ones, like prohibiting them from committing any further act of domestic violence, or even attempting it. Prohibiting them from enlisting other people to commit violence on their behalf.
Okay.
It can prohibit them from entering a shared residence if that's in the complainant's best interest, or even just a specific part of it, or entering the complainant's sole residence if they live separately.
What about work or study?
Yes, it can prohibit entry into the complainant's workplace or place of study. It can also prevent the respondent from stopping the complainant from entering or remaining in a shared residence, preventing lockouts, basically.
And you mentioned cyber abuse earlier.
Yes, a significant update from 2021 specifically allows the order to prohibit the respondent from disclosing any electronic communication or making available any other communication as specified in the order, directly tackling things like revenge porn or sharing private messages.
Okay, so strong prohibitions. What else can the court order?
Beyond just stopping bad behavior, the court can impose crucial additional conditions. For example, ordering the seizure of any weapons the respondent possesses. And this is important. Section 9 makes seizure mandatory if the court finds the respondent threatened violence or is otherwise unfit to have a weapon, regardless of whether they need it for work, like security or police.
That's a strong stance on weapons.
Very. The court can also order a police escort for the complainant to safely collect personal property from a shared residence. It can make recommendations for criminal prosecution, if appropriate. It can even establish obligations regarding rent or mortgage payments for a shared residence to prevent homelessness.
Financial aspects, too?
Yes, and crucially, it includes the power to grant emergency monetary relief. This is for immediate needs arising from the violence.
What kinds of needs?
It can cover losses like earnings, medical expenses, relocation costs, emergency accommodations, school fees, even just household necessities, and maintenance for dependents, pending more formal proceedings, like through the maintenance court. This order actually has the legal effect of a civil judgment.
So it provides vital financial support quickly.
Potentially, yes.
Yeah.
Another newer power is referral for substance abuse treatment, if that's a contributing factor.
And what about privacy? Protecting the complainant's location.
Very important point. Section 7.5 specifically mandates that the complainant's physical address, home address, study address, work address, and even their contact details must be omitted from the protection order served on the respondent, unless it's absolutely necessary for the order to be effective. And for children, these details are absolutely not to be disclosed until a children's court inquiry has been held. Privacy and safety are paramount.
That sounds incredibly comprehensive in terms of proactive protection and support. But, this raises the crucial question. How is all of this actually enforced? What happens if someone just ignores the order? Because a law, no matter how good it looks on paper, is only as effective as its enforcement, right?
That's the critical point, absolutely. And the Act has some very robust enforcement mechanisms built in. It starts with Section 8, which deals with a warrant of arrest.
Okay.
Crucially, a warrant for the respondent's arrest is issued at the same time as both an interim and a final protection order, automatically.
They're not arrested immediately.
No, the warrant's execution is suspended. It hangs there, conditional on the respondent complying with all the terms of the protection order. It's like a warning. Follow the rules, or this warrant gets activated.
Okay, so what happens if they don't follow the rules? They breach the order.
If a complainant believes the order has been breached, they report it to the police, usually by filing an affidavit explaining what happened. The police must then consider factors like the risk to the complainant's safety, the seriousness of the alleged breach, any history of violence, and if there are reasonable grounds to suspect that the complainant is suffering or may suffer harm as a result of the breach, the police must immediately arrest the respondent.
Must arrest, not may.
Must arrest if those conditions are met. It's intended to remove discretion where harm is likely. This significantly empowers both the police to act and the complainant seeking enforcement.
And what are the consequences for breaching an order?
The penalties for offenses under Section 17 are serious. Contravening any condition of a protection order is a criminal offense. It can lead to a fine or imprisonment for up to 5 years for a first conviction.
And for repeat offenders.
For subsequent convictions, it can be up to 10 years imprisonment. It also makes it an offense, by the way, for anyone to fail to report domestic violence when they have reasonable grounds to suspect it's occurring against a child, a person with a disability, or an older person.
So there's a positive duty to report for vulnerable groups.
Yes, under Section 2B.
Okay, if we connect this to the bigger picture then, this really isn't just about individual protection orders. It feels like a much broader push for systemic change. What responsibilities do state organs and maybe even ordinary citizens have in making this whole act work?
This is where the Act becomes truly holistic, moving beyond just the courts. It places clear duties on various actors across society. For instance, the SAPS, the police service, has a specific duty to assist and inform under Section 2.
What does that involve?
Police officers arriving at a domestic violence scene, or when someone comes to the station to report, must render assistance. They must provide prescribed information about the complainant's rights and the remedies available under this act, including helping them find shelter or medical help and explaining their right to lodge a criminal complaint alongside the protection order process.
So police have specific obligations. What about others?
Yes, Section 2A outlines obligations of functionaries. This makes it mandatory for certain professionals, medical practitioners, healthcare personnel, social workers, public health officials, educators, even caregivers to report suspected domestic violence if the victim's a child, a person with a disability, or an older person. They must report it to a social worker or the SAPS.
Mandatory reporting. Are they protected if they report?
Yes, they are explicitly protected from civil or criminal liability if they report in good faith. This encourages reporting without fear of reprisal.
And you mentioned a public duty, too.
Yes, extending this even further, Section 2B establishes a public obligation to report. Any adult who has reasonable grounds to suspect that an act of domestic violence is being inflicted on a child, a person with a disability, or an older person must report it to a social worker or the SAPS. Failure to do so is actually an offense.
Wow, that's a significant obligation on everyone.
It really aims for a societal response. Police also have expanded arrest powers without a warrant in certain domestic violence situations involving violence, and specific powers under Section 3A to enter private dwellings without a warrant to investigate and obtain evidence if an offense involving physical violence is reported during a domestic incident.
So, fewer procedural barriers in emergencies.
That's the idea. And finally, there's significant institutional accountability. The National Director of Public Prosecutions has to determine prosecution policy specifically for domestic violence cases. The National Commissioner of SAPS has to issue national instructions to ensure police members comply with the act.
So, top-down directives.
Yes. And crucially, various government departments, health, social development, basic education, higher education, communications are mandated to issue their own directives. These cover things like ensuring widespread implementation of the Act within their sectors, public education campaigns, training for their staff, and ensuring the provision of essential services like shelters, counseling, and risk assessments. This multi-agency approach is key.
And what if officials don't comply?
Failure by police members or these designated functionaries to comply with their duties under the Act constitutes misconduct, potentially leading to disciplinary action. It holds the system accountable.
This comprehensive framework really shows a commitment, doesn't it? Not just to provide relief after the fact, but to actively try and prevent, report, and address domestic violence at multiple levels, holding various public actors and even private citizens accountable.
It's certainly designed to be a system-wide response.
What a truly insightful deep dive into South Africa's Domestic Violence Act 116 of 1998. It's clear this is, well, intended to be a powerful, evolving tool designed to provide maximum protection for victims.
Yes, I think we've seen how the Act has significantly broadened its scope over time, defining domestic relationships and violence in these incredibly comprehensive ways that try to reflect the lived realities of many people, much more than just physical violence in marriage.
Right.
And it's introduced these innovative measures, like the safety monitoring by police, which could be a real-time lifeline for someone in danger at home, and the direct intervention with electronic communication service providers to tackle that growing threat of cyber violence. Crucially, it aims to empower victims by making the application process more accessible, especially with electronic filing. It places those significant duties on state functionaries and the public to report abuse, particularly for vulnerable groups. And it ensures, or tries to ensure, robust enforcement with specific legal consequences for noncompliance.
It's a powerful piece of legislation, constantly adapting, it seems. But as we finish this deep dive, it really leaves us with a thought for you, our listener.
Food for thought.
Legislation like the Domestic Violence Act provides the essential framework, the architecture for justice and protection, but laws alone, we know, don't solve deep societal issues. This act mandates reporting, it outlines state duties, but its true spirit, its effectiveness, is really lived through the actions of individuals, families, and communities.
It requires buy-in.
Exactly. So the question for you is, how will the comprehensive nature of this act and its clear emphasis on a multi-agency, public inclusive approach challenge and perhaps empower you and all of us to contribute actively to the elimination of domestic violence in our own daily lives and communities?